Mr. Roth, you want to answer the questions with regard to this contention one?
Certainly. And first, Your Honor, is David Roth for the staff. Some time ago, you inquired about reporting requirements for tech spec files.
Yeah, we're gonna, well, go ahead. What do you got on it?
Sure, because I'm trying to get it while it's still fresh in my brain. In 5073 A2,
Okay.
capital A, the licensee shall report the completion of any shutdown from plant tech specs. In B, it's the operation or condition which was prohibited by the plant's tech specs, except when the event consisted solely, and this jumps down to another paragraph, there's many subparagraphs, this is now B2, except when the event consisted solely of a case of a late surveillance test where the oversight was corrected, the test was performed, and the equipment was found to be capable of performing its specified safety functions. Or the tech spec was revised prior to discovery of the event such that the operation or condition was no longer prohibited at the time of discovery of the event.
Okay, so what's the import of that?
You'd inquired about if they missed a surveillance test.
Yes.
And whether that was reportable or not.
Yes.
And so my quick read of this, of course, it would be fact dependent on the test. If whatever caused them to miss it, the oversight was corrected, and the equipment was found to be operable, then that would not be reportable. Whereas if the equipment was tested in the surveillance test and it failed, a quick read of this suggests that would be enforceable.
No, I guess what let me just ask, there's a surveillance frequency specified in the tech specs currently, okay? Let's just assume once per day, whatever. And you take that surveillance frequency and you move it out of the tech specs into a licensee controlled document. Those are situation A, situation one's in a tech spec, one's in a licensee controlled document, same surveillance frequency, and you miss. The licensee doesn't do it once per day. They forget, or something happens and they don't do it once per day. If it's in the tech spec, is there a difference in the reportability if it's in a tech spec versus it's in a licensee controlled document?
Absolutely not, Your Honor, because the surveillance frequency continues to be specified through the requirements of the surveillance frequency control program. So the new license, should they get it, would tell them do the surveillance in accordance with the control program.
Yes.
The program specifies the documents they're supposed to follow. So, that the surveillance frequencies they're supposed to be using. So, from the enforcement perspective, it would appear to have no difference.
I'm not thinking of enforcement. I'm thinking of just reportability.
And the same thing. It would have no difference. It's still a required surveillance.
Okay, and could you give me the site on that, Reg, so that when we go and look?
5073 little a 2 Roman I B, capital B.
All right. Thank you.
But I'm not sure I understood what you said, because if I heard what I thought I heard, it doesn't sound very logical to me. If I miss a TRM surveillance, and then 2 days later I do it, I realize I missed it and I do it. When I do it, I find that I met the tech specs. That's not reportable. But if I do it and I find I didn't meet the tech specs, that's reportable. Well, it would always be reportable if I did a surveillance and it did meet the tech specs. I mean, I don't understand why there's any significance here regarding the TRM or not.
Your Honor, I fully agree. It makes no difference whether the frequency is specified in the TRM as the proposal would be, or whether it was specified in the current license. Relative to reporting requirements of 5073, the missed surveillance would be unchanged.
Right. Yeah. Now, in the enforcement space, there'd be an LER, and in the LER, you would probably be saying, or the licensee would probably be saying, we missed the surveillance frequency, and there might be an enforcement issue associated with that. But I guess that would be at the discretion of the staff.
Well, go ahead. Do you have an answer for that? Or is there an answer?
No, I believe Your Honor characterized it correctly.
Okay, I'm looking at the reg, I found the reg you cited, 50.73, entitled Licensee Event Report System, right? And 5073A says, A is reportable events, right? And 5073A2 says the licensee shall report. Am I with you so far? Am I following? So
Yes.
A2, little I, B. Okay, so licensee shall report any operation or condition which was prohibited by the plant's tech specs. So that, is it, am I following you there?
Yes, that's fine.
Okay, so if it's in a tech spec and you don't meet it, you gotta report it. But if it's not in a tech spec, this doesn't say you have to report it, does it?
No, and
Okay, but I thought you said it was the same. If it's a tech spec or a licensee control document, both this reg says you have to report it if it's a licensee controlled document. That reg doesn't say that, does it?
you have to consider, Your Honor, that the surveillance frequency is specified within each requirement, each section. Or we'll choose like 341, for instance.
We just took it out of the tech. We just took it out of the tech specs, and this says if it violates a tech spec, you got to report it. Well, it's not a tech spec, so the implication is you don't have to report it.
Your Honor, the surveillance requirement remains. Now the surveillance requirement states do the surveillance in accordance with the surveillance control program. So that's the frequency that's specified.
Okay, that's the surveillance control program, which is a licensee controlled document, which is not a tech spec.
The requirement to do this remains in the tech spec. The surveillance requirement remains in the tech spec.
What requirement?
The requirement to perform the surveillance.
Okay, so there is a tech spec that says you got to do surveillance in accordance with the surveillance frequency control program document.
Exactly.
And if you don't do something in compliance with the surveillance frequency control program document, then that's a violation of that tech spec, and therefore that is reportable.
Reporting depends on whether it failed or not, but actually,
Right.
there would be two tech specs. You would have the tech, well, at least two. You would have the tech spec for the specific equipment, usually in the section 3 of the tech specs. And in addition, within section 5 of the tech specs is the actual statement about following the program. So I could see potentially a violation would involve both not meeting the admin controls in section 5 as well as the specific equipment surveillance requirements in section 3.
So is there a condition in the license now, or as it is requested to be amended, which says you must you must comply with the surveillance frequency control program?
Yes, there
And what is that? Do you have a site for that?
it should be in our pleading. I'll pull it up here within section 5 in a moment.
Great. No, that'd be very helpful, because that seems relevant to me, whether it's the difference, a qualitative difference between being in a tech spec or being in a licensee controlled. Maybe Mr. France has that site.
Yes, I refer the board here to our license amendment request, attachment 1, volume 14, page 83, and it's proposed tech spec 55218.
5.5, is it 5.5.2.18?
That's correct.
Okay, great. Thank you. That's helpful. I wanted to go back, Mr. Roth, on a couple other of the questions we asked Mr. France and see if you agree with him or have a differing opinion. The question, if you relocate, quote, this provision from the license, from a tech spec, and put it into a license control document, is it no longer a tech spec?
No, Your Honor, and let me...
All right, it's still a tech spec?
Let me segue on the relocate. Previously, in looking at the SAS Federal Register notice, Your Honors were discussing the section on relocated specifications.
All right.
And that would be on page 49465, so 77 Fed Reg 49465. The paragraph immediately below that is actually the relevant paragraph.
All
That's
right.
the remove detail changes.
All right, hold on a second, let me get back to that, okay. We're on 49467 is what I was questioning about. Are you on 49465?
Yes, we'll get to 49467 in a moment.
Okay, 49465, okay, where are we? What column?
And the one that starts with removed detail changes, and I don't have the column format, I'm sorry.
Okay, I'm sorry, let's see. Well, removed detail changes. Okay, is that what you're referring to?
Indeed, and
Okay.
in that one, the details that are removed are referring to the details including the surveillance frequency control program.
Yes, I see that.
And so that actually is the what is happening. It's not removal of surveillance requirements, it's removal of the detail within the surveillance requirements.
Okay, so you're going back to the same provision, which is you're saying, well, there is a tech spec that says you must comply with the surveillance frequency control program.
Yes, that's right, Your Honor. There's multiple tech specs. Each individual equipment that is subject that will use the surveillance frequency control program, pipe component.
So is the surveillance, you got a surveillance frequency currently in the license. You're taking it out of the license and putting it into a licensee, they call it licensee control document. And the surveillance frequency control program is a licensee control document.
The program is not a licensee control document. That's the NEI document, which is incorporated directly in the tech specs through proposed tech spec 55218.
Now, is there a document? I mean, they got a surveillance control program. Is that can I find a piece of paper that says here it is? This is the document that is the program. And is that NEI 0410 or was it something else?
Well, that is in the plain language of the tech specs. The surveillance frequency control program shall consist of a list of frequencies, requirements for which frequency is controlled by the program. Changes to the frequencies are in the surveillance frequency control program, and they shall be made in accordance with NEI 0410. And so, a program could have multiple meanings to multiple people. So the simplest thing is, here's the actual proposal as to what the licensee elects to call a technical requirement manual, a list of surveillance frequencies. Have exactly the information they may choose to call it.
Okay, so Mr. France seemed to say that if you take it out of the license and put it into a licensee controlled document, it's no longer a tech spec. And you're saying, oh, but it is because the licensee controlled document is a requirement in a tech spec. Is that your logic?
To be very clear, the surveillance requirements remain within the tech specs. The program used to change them remain in the tech specs. There has to be...
Wait a second, the surveillance frequencies are in the license now. Now they're going to be moved to a licensee controlled document, and yet you say they're still in the tech specs.
Yeah, in proposed tech spec 55218A.
Okay, I got you. That's your logic, how it gets there. Okay.
Yeah, and I'm not sure you
Did I mischaracterize you, Ms. France?
Again, like Mr. Roth, what I was saying is that the frequencies were removed, not the surveillance itself.
Well, that's what I was trying to refer to, the frequencies.
Yeah.
Do you agree with Mr. France that, the frequencies aren't tech specs, but the surveillance requirements are? Are the frequencies still tech specs?
As to the frequency being a tech spec, the frequency is no longer contained within the tech spec, except that they must maintain a list of those frequencies. The actual number, once per year, you're quite right, it's not going to be within the tech spec.
Okay.
In the list of frequencies, the requirement to have that list remains in the tech specs. Change of methodology remains in the tech specs.
Okay. And now, and when you relocate the tech spec, the frequency from the tech spec to the licensee controlled document, does it become what's referred to in the parlance as a written commitment, a licensee voluntary written commitment?
No, it would be a requirement that they have this list of frequencies directly stated within the tech specs, which are part of the license.
Well, let's jump to 10 CFR 54.2, there's a definition of current licensing basis, right? And in that definition of current licensing basis, they talk about the stuff that's in the license and the stuff that's in the written commitments by the licensee. Which one is the surveillance frequency control program?
Well, I haven't given much thought to the 54, the list, which is the list of current licensing basis for renewed plants. But again, the list is required by this plant's tech specs. The methodology of changing the list would be...
They can change it anytime they want, so long as they meet NEI 0410, right?
Correct.
So it's a licensee-controlled document,
Yes, Your Honor.
and they can change it whenever they want.
Within the realms of 0410, I don't have a specific knowledge whether they could change it every day or if that would be against 410.
And is there a legal distinction between, is a written commitment by a licensee legally enforceable by the NRC?
Then, as a general principle, if would depend on what the type of commitment was. If they made the commitment to us and it's incorporated into a license condition.
If it's incorporated in a license condition, yes, but I didn't say that because there's another board that's out there, Progress Levy, and on November, as I saw it, September 21st, the board asked the parties to brief the following question, quote, are voluntary commitments made by a licensee legally enforceable by the NRC? And the NRC staff said no. And the applicant said no, and they're represented by John O'Neill, who's a pretty good attorney, it seems to me. So what is your answer to that? Are voluntary commitments made by a licensee legally enforceable by the NRC?
I would first say this is not a voluntary commitment made by...
Okay, so I understand that's your position, but are they enforceable?
I would presume not.
Okay. Mr. France?
I agree with that. The NRC,
That they are not enforceable.
the NRC can and then sometimes does issue what are called notices of nonconformance for a violation, if you want to call it that, of a commitment. They can't issue, for example, a civil penalty associated with that.
And now, Mr. Roth, another question about the difference between, well, what the impact of the proposed change, public access. Assume that the request is granted, the proposed license amendment is granted. And one of the concerns Mr. Lutz has raised is that, well, look, if it's in the license, the public can see it. If it's in this licensee-controlled document, it's not accessible to the public. Is that correct?
Yes, Your Honor, that would be correct. Certainly, if we had it in-house and it was subject to a FOIA,
Well, I get FOIA if you had it. All right.
it would no longer be within the tech specs.
Right. And
Pardon me, I have to be clarified, no longer within a document that they would clearly see. I understand our tech specs are currently public and easy to see. The proposed frequencies, although we cited one example where it's publicly available, it's my understanding that plants normally don't submit those to us.
Okay, and do you agree with Mr. France, and this is sort of the same thing as I understand it, that, well, let me back up. Under 5059, do you agree that the licensee must submit reports to the NRC about 5059 changes that they've made?
I believe the reports are showing up every 2 years. I would have to double check that.
Yes, that's what the reg seems to say, no more than 2 years. Now, with regard to licensee-controlled documents such as the surveillance frequency control program document, whatever that is, do they have to submit reports to the NRC when they change that document?
I do not believe that reports are part of the NEI 06 process, the NEI 0410 process, or
Right.
I do not believe so.
Okay. So if NRC audited the facility, you could go and look at those documents, and right?
Certainly so.
And okay.
Well, let me interrupt here. This is kind of critical for me. I heard earlier that changing that process is a license amendment that would be, that would then make it available for petitioner intervention.
If they elected to use a process other than the specified or proposed in this instance, the Rev 1 of 0410, they would have to have a license amendment.
So if we go to an 0410 Rev 2, that's a license amendment.
That's correct.
But it's not a license amendment if under 0410 Rev 1, they make some changes to the surveillance frequencies. That's not a license amendment.
That's not.
No,
Right.
and I speculate that even if they decided to shift to a different revision, if the staff chose to approve one, they would not include the list of current surveillance frequencies, but I'm entirely speculating on that.
Mhm.
Just one question on sort of a big picture question. This is not the first plant to do this, correct?
No, I believe this would be licenses number 50 and 51 should be granted.
51. So there's plenty of data out there regarding the effect of this program. For example, is the staff seeing an increase in safety LERs?
No, they're not, Your Honor. At least to the best of my knowledge, they're not.
Okay, so there hasn't been, because the proof of the pudding is in whether or not there are any violations of the tech specs that come out of this program. And you're saying there hasn't been anything beyond the ordinary?
Correct, Your Honor. I am informed that that has not occurred.
I've got a couple of questions for you. When did the Southern California Edison submit these proposed changes?
Have to consult with FedReg notice here to see the date. July 29, 2011.
2011. That's good. Okay. I'm now much more familiar with the COL process and the license renewal process, things like that. Did the staff do a sufficiency review to see if there was enough material to review?
Yes.
Okay. Is it customary that once that sufficiency review is done, that the amendment be either docketed or noticed?
Yes, Your Honor. We did notice this amendment. We have the FedReg notice.
Why then did it take over a year for that to occur?
I could not speak to any delay. The amendment has not been granted. It was noticed and a hearing request was put forward.
Well, it seems like there's a disconnect between 13 months, or let's say it take you 2 months to do a sufficiency review. Say a year late and 2 days late, isn't it? Seems to be like a couple orders of magnitude difference there, isn't it?
I do not believe the staff is late in terms of any regulation with their FedReg notice.
Well, custom, though, would dictate otherwise, that you would be a little more punctual. I guess that does bother me a little bit, since you did not, you criticized the Citizens Oversight Group for not filing within the allotted time for requesting a hearing. It seems as though you did not notice it within a reasonable time of having received it. Let me go on to the next question here. If what you say is correct, that the 5059 is not required to be done, nor is there a reporting requirement when a frequency is changed, there is then, as has been alleged, a relaxation of oversight. Is that correct?
To the extent that oversight refers to requesting a license amendment, yes, that's correct.
Okay. Yeah. Or to being subject to reporting requirements. Is that correct?
No, the reporting requirements do not change. If they fail to make, if the surveillance fails, the LER process is still...
No, I'm referring to reporting requirements of changes to the... Under 5059, you could make a change to some things, and you have to report it. But under this program, you do not.
Under 5059, they could not make a change to the previous surveillance requirements, period. So the reporting requirements are academic.
All right. You also mentioned that SCE's proposal includes establishing an independent decision-making panel. From a professional standpoint, given the aging of the industry, do you expect the members on that panel to have much experience?
Your Honor, I could not speak at all to what SCE's decisions are as to who's going to be on their panels that they put together in accordance with the requirements of NEI 0410.
Well, you do speak to that in your pleading, I say, so I thought you'd be more knowledgeable about it.
I can speak that this is what the requirements will be as to when they actually have the panel and who's going to be on the panel. That's the licensee's decision. The NRC would inspect to make sure they're following the requirements of the panel under the oversight of the reactor oversight program.
Judge Barata, if I may, this may help. NEI 0410 does have a list of individuals who should be on this independent decision-making panel. And I'll refer the board here to Exhibit 1, page 4 of that guidance document. And among the members who have to be present, or at least part of the panel, include the engineering manager, maintenance manager, operations manager, maintenance risk coordinator, work control management. So it's management, basically management level personnel, plus people like the surveillance test coordinator. So it's fairly experienced personnel.
So you don't have your oversight committee that involved in that at all?
I assume, such as anything else, it's subject to QA audits and surveillances. But you're right, I don't see any member from the QA organization who's present or a member of the panel itself.
All right. There is a statement that appears, starts on page 17 of your the staff's pleading, in that you say that the Citizens Oversight determines that a particular frequency must be used and furthermore must be specified in the tech specs, then they may request the NRC instead of proceeding to modify the license to specify a particular frequency. Now, earlier you made a statement that such things are not subject under the AEA to public scrutiny. That seems to contradict that. Are you?
I'm uncertain which area is the source of confusion. However, cops can always file a 2206, and through the 2206 process, they can request the director to modify or amend the license or take whatever actions are appropriate and necessary. So if they conclude that a diesel test, for instance, should be performed once a month rather than once every 2 months, they may certainly petition the staff to make such a change to the license.
Yeah.
Okay. I think I have one last question for Mr. Roth, and then we're going to go back to Mr. Lutz to wrap up contention number 1, and then we're going to take a short break and go to contention 2, and hopefully finish by 5 o'clock, 1 hour. But anyway, my one last question for you, Mr. Roth, and it's the same one I asked Mr. France, and it helped me with 50.36C3. Okay, that's the reg that talks about surveillance requirements. And being a novice in this area, I look at, when I saw this contention about surveillance frequency and surveillance requirements, I said, this is the relevant reg. This tells us that surveillance requirements must be tech specs, and yet when I read the Federal Register notice, I see everybody's focusing on 50.32C2II A through D, the 4 criteria. So, do you agree with Mr. France, essentially, that the surveillance requirement provision of 5036C3 just says you got to have surveillance requirements and frequencies are not relevant or part of that?
That's correct, Your Honor. The surveillance requirements remain within the technical specifications. The only thing which is now not going to be directly visible in technical specifications is the once per week, once per month, once per year number.
And those are the frequencies, and those are not covered by C3. Is that what you're saying?
That is correct. Under C3, there's no requirement that the frequency be specified within the tech specs, just as there's no requirement that the
Is there any law that says C3, that's what C3 means when it says surveillance requirements? That it means you gotta have them, it doesn't mean any of the specifics of how frequent they should be or what they should be or anything like that?
I believe Your Honor's decision will be the first decision addressing this.
Perhaps, not if we can avoid it. No. It's pretty esoteric.
Now, I'd also like to go back and revisit the Fed Reg notice. As I discussed earlier, this is a removal of details, and the Fed Reg notice spot that you read before was actually one on relocated specifications, not on removal of details.
Right. Now, that's what, one of the things is Mr. Lutz's citizens oversight is, this contention seems to be focusing on the relocation. I mean, there are other parts of the tech spec that deal with relaxation of the frequency, relaxation of the method, deletion. They didn't object to that.
No, but this is to clarify so Your Honors have the right
Okay.
section of the Fed Reg. And again, I have the Westlaw printout, I don't have the column version. But on page 49467, as you look down or across the columns, you'll see a separate section addressing the proposed no-sig hazards for the removed detail changes. And since the removed detail includes the surveillance frequency control program, that is the section that the staff intend to be applied for the no significant hazards consideration for the surveillance frequency control program.
Okay. I see the removed detail provision on 49467.
Judge Carlo, can I make one more statement in response to something that Mr. Lutz raised? You said we're going to be using this program to reduce surveillance frequencies. That may be true in some cases, but in other cases...
No, I didn't say that. I don't think
Mr. Lutz did. I want to respond to something Mr. Lutz said. In some cases, of course, we actually may be increasing the surveillance frequency.
Okay.
Under NEIO 410, we're supposed to do periodic monitoring.
Okay, I understand. Mr. Lutz, we're going to give you a chance to, you've heard a lot of it, presumably some of our questions. I don't know if there's anything, I don't have any additional questions for you, sir, but do you want to say anything about what on contention number 2, based on what we just discussed?
No,
Contention number 1.
Okay, yes, thank you. Yes, I do. I have a few things I'd like to bring out here. First of all, I'd like to, if possible, have you turn to page 4 of NEI 0410. Page 4.
I'm sorry, I don't have that in front of me, but...
Okay, well, let me just tell you what it says. It says, it's a reference here. It says the method described here is also consistent with RG 1.174, reference 6, I'm going to skip that one, and RG 1.177, which is, quote, an approach for plant-specific risk-informed decision-making, technical specifications, and unquote, and provides more specific guidelines to facilitate application by the licensee. So it claims at this point, and this is the control frequency control program that everybody refers to. It actually says that it is consistent with this other document, and that's the one that I brought out earlier. And I had those various sections that I detailed, which state that the this plant-specific risk-informed process would be submitted as license amendment. Each time they go through and they say, gee, we want to change these frequencies. Like, Citizens Oversight has no trouble with the operators of the plant reviewing the surveillance frequencies and deciding that they might want to change them, even increase them, or maybe reduce them substantially. There may be some good reasons for that, but we object to the idea, and it also is not supported. It is not consistent with this other document. In that document, the process is it goes through the license amendment process. Now, furthermore, on this same document, and you don't have it there, but in your review of this, maybe later when you get a chance, if you would look at, there's a whole bunch of steps, and there is a step 7. Step 7 is identify qualitative, it's on page 10, qualitative considerations to be addressed. So this this is a very long section. There are 14 steps in this control program. The whole document is, looking at page numbers here toward the end, 33 pages. On step 7 is a whole bunch of qualitative issues that have to be addressed. And we're relying upon the licensee to go through the process of, without any review from anybody, addressing all of these things, such as impact on defense in-depth protection, vendor specified maintenance, test intervals, impact in an adverse environment, and they're supposed to document assumptions in the plant that would be of the license that would be invalidated. No one gets to review that, so it's all put in the hands of the licensee to. So the license, essentially, the control frequency control program lets them change anything they want once they get through this qualitative thing. There's no review or anything, and there's so much looseness in this whole program. This is not just an equation that you type in on a spreadsheet and you get an answer. This is a big process, and to put it in the hands of the licensee without any review is unacceptable. Now, I'd like, if you can, the document that I was referring to, which is volume 7 of the attachments in the license amendment, that is a document under question here. Is there a possibility that we can take a look at page 88?
We don't have that available to bring up.
Okay, in that case, let me just tell you what it says, and I'll invite you to take a look at it later. On page 88, it has a title that says surveillance requirement 3.4.4.1. That's the number of the surveillance requirement. It actually says SR 3.4.4.1 for a surveillance requirement. And in the first column it says surveillance. And in the second column it says surveillance frequency. The definition of a surveillance requirement, SR 3.4.4.1, is both a surveillance, what's going to be checked, and how often it's checked. Those two things are not something that they can split up. A surveillance requirement has to incorporate both things, both what you're checking and the fact that you're going to check it. You can't just say you're going to possibly check something and then never do it. All right. Now, I heard these things from the testimony, that they do not require to get any NRC approval for going through this process and changing the surveillance frequencies. There's no mandatory reporting once it's pulled out and it's no longer a technical specification. They can change it at any time. Therefore, they'll never violate it. They'll change it so they'll never violate it. They say, oh, we went over that, well, just quickly change it. And then we're not in violation. And even if this list of surveillance frequencies is not even submitted to the NRC, no one gets to see it. Not even the regulatory agency gets to see it, and they're not notified.
Mr. Lutz, okay, let me just ask you, your earlier point about you were referring to 3.4.4.1 and surveillance requirements. I guess as I'm understanding your point is that the surveillance requirements as reflected there include both the frequency and something else.
A thing called the surveillance. The surveillance is it's called the surveillance and the surveillance frequency, according to that page.
And therefore, when I'm talking about 50.36C3 that talks about surveillance requirements must be in the tech specs, you're suggesting that frequency is part of the surveillance requirements that must be in the tech specs. Is
yes,
that right?
That's my point. And okay, so my point is then made. Then we were saying that this list of, let's say they're pulled out of the tech specs, and they've got this long list of frequencies somewhere else, and that's not submitted to the NRC. No one gets to see it, and they're not notified if it's changed. They can change it as fast as they want, so that there's no way it can violate. So this comment that other plants are doing it, actually, I hope that's not really entertained in this sort of proceeding as a reason to allow them to continue to do something. Two wrongs don't make a right. The fact that staff is not getting notified, this idea is that it's proof of the pudding that there would be no violations. They'll never have a violation because they can change the surveillance frequencies at will. So if you ask the person, the licensee, you regulate yourself. You tell me when you violated those frequencies that you maintain yourself, and I never get to know about them, and just tell me when you violate them, and that's going to be proof of the pudding? I mean, what happened to the regulatory agency here?
Okay, we're gonna need a biological break here in a minute
Okay,
or two.
so that's-
and
that-
go on to contention too, so you can.
That's
you
the
can
end of
wrap
my-
This up a little bit.
That's the end of my my rebuttal statements.
Okay, thank you, Mr. Lutz. So, at this point, we need to take a quick break, and we're gonna come